Hello, I'm Rashi Goel and I'm pursuing BLLB from University of Petroleum and Energy Studies, Dehradun. And currently, I am a legal intern at LEXIS and Company for the month of June. So in today's video, I'll be talking about child marriage laws. Childhood is considered as a golden period of person's life. Any person in his childhood is too innocent to understand the cruelty and harshness of society. A person can be sharpened in his childhood period only. But due to some evil practices in society, the future of beautiful and innocent children gets sacrificed and destroyed. One of these evil practices in Indian society is child marriage. Child marriage as a practice is not new in our Indian society. Child marriage can be defined as a marriage which is solemnized between two people where female is below the age of 18 years and male is below the age of 21 years. Child marriages usually takes place in rural areas where illiteracy and poverty are widespread. Many factors effectuate child marriages such as ignorance, social customs, traditions, low level of education, and considering women as a financial burden. Now first, let's talk about the Prohibition of Child Marriage Act 2006. According to this act, any marriage in which either or both of the contracting parties is a child will be considered as child marriage. According to section 2 of this act, a child is if any male who has not completed the age of 21 years and if any female who has not completed the age of 18 years will be considered as child marriage. Under this act, any person performing, abetting or conducting or even directing a child marriage would be punishable with the rigorous imprisonment for a term which may extend to 2 years and a fine which may extend to 1 lakh rupees. Any person who promotes or permits child marriage would also be liable for the rigorous imprisonment or punishment for the term which may extend to 2 years and a fine which may extend to 1 lakh rupees. Any adult male who contracts a child marriage shall also be punishable with the rigorous imprisonment of term which may extend to 2 years and fine that may extend to 1 lakh rupees. So the main object of this act is to prohibit the solemnization of child marriages, to protect the victims of child marriages, to provide relief to the victims of child marriages, and lastly to punish any person who promotes, performs, encourages or directs the child marriages. Now let's talk about the Indian Penal Code 1860. Under section 375 exception 2 of IPC, if the wife is not less than the age of 15 years, then her husband can have sexual intercourse or sexual act without her consent, and this would not amount to rape. This marital rape exceptions of IPC contradicts with the provisions of Prohibition of Child Marriage Act and discriminates between the married and unmarried girl child of below 18 years of age. Next is POCSO Act. POCSO Act stands for the Protection of Children from Sexual Offences Act. This act was enacted to protect children from all kinds of sexual offences in 2012. Unlike Indian Penal Code, the act provides for the protection against sexual offences for boys as well. Unlike Indian Penal Code, the POCSO Act holds no such exceptions to have sexual intercourse with a girl child even after marriage. Any child below the age of 18 years will be considered as child whether married or unmarried. To remove the confusion that whether Indian Penal Code shall prevail or the POCSO Act, the Criminal Law Amendment Act 2013 amended Section 42. Section 42A of the Act states that after the amendment, provision of all the POCSO Act shall be in addition and not in derogation with the provision of other law. In case of inconsistency, the POCSO Act shall override. And last is Hindu Marriage Act 1956. Under the Hindu Marriage Act, only the parties to a child marriage are punishable even if they did not consent to the union. There are no provisions for punishing the parents or people who solemnize the marriage. A girl can get marriage annulled only if she was married off before attaining the age of 15 years, and she can challenge the marriage before turning 18. There is no express provision to prohibit child marriage per se. So, it can be concluded that child marriage is a menace that cannot be curbed without the support from the society. There have been demands to make child marriage void ab initio under the Prohibition of Child Marriage Act. But Indian society is so complex and complicated, and making child marriage void ab initio or void will only jeopardize the rights of women who are victims of child marriage. Mere legislation will not serve the purpose unless there is no support from and back from the society. Uniform civil code will only help in preventing the child marriage to some extent. Thank you everyone for watching my video. I hope you like it, and if you did, please give it a thumbs up and share it with your friends and family. And don't forget to let me know your feedback in the comment section. Stay home, stay safe, stay healthy.